Hello students, welcome to Legacy Health Academy. In this video, let us try to discuss the recent amendment that has been proposed by the Himachal Pradesh Legislative Assembly related to raising the minimum age of marriage for the girl or woman. So let us try to understand what are the key provisions of this proposed amendment and what are the concerns raised by the Women Welfare Organization. So first of all, to give you the brief background of the issue, Himachal Pradesh Assembly recently has passed a bill where it has proposed to raise the minimum age of marriage for the women from 18 years, that was earlier, to 21 years as of now. To remind you, as of now in India, the minimum age of marriage for male is about 21 years, while for female it stands for 18 years. Now the provision of child marriage Himachal Pradesh Amendment Bill 2024, it seeks to amend the earlier act which was passed in year 2006 to advance gender equality and encourage higher education among the women. Now these are the two primary reasons that has been given by the government to justify its stand on the proposal of this amendment to the 2006 bill. Earlier in June, a similar bill, that is a central bill that aimed to bring uniformity in the minimum age of marriage for women and men, lapsed after it was sent to the parliamentary committee, but overall parliamentary committee was not able to submit its report at time. Now in this regard, if try to understand that what is the rationale behind this bill. So the Congress government, which is currently we can say is ruling in the Himachal Pradesh, it has said that Congress has showed its commitment to advance the welfare of women, and this particular step we can say is going in the same direction. In this context, the ministry has said that the early marriage obstructs the girls' education and limits their potential for progress in life. This if we largely understand from the prism of the higher education, because most of the higher educational institutions, whether it is professional education, whether it is technical education, or whether it is simple education, graduation, we talk about, there the education has to be continued beyond 18 years of age, and thus if a girl is married at 18 years of age, then obviously there is an obstruction in the path of her career. Second, it also has said that to reduce the instances of early pregnancies and motherhood, which is a result of early marriage, it will also adversely affect the women's health. So not only to ensure that they can move smoothly in their career path, but also to take care or ensure their good health, well health, is the bill has been proposed or the amendment has been proposed. Third is to provide for a gender equality, because right now the age of marriage, minimum age of marriage for man is or male child is 21, for female it is 18, so there is a kind of gap. So this also will fill this gap and will also ensure gender equality as well as opportunity to obtain higher education, as we have discussed. So it is due to these three reasons the amendment has been proposed. Thus it is proposed to amend the acts in the application to the state of Himachal Pradesh and increase the minimum age for marriage for girls to 21 years. That is the overall statement of provisions for the bill that it says. So if you look at the key provisions of this recently proposed act, what are the key provisions? First of all, the gender-based distinction that exists in the earlier law, that this bill is trying to remove, and it redefines the child as whether male or female who has not completed 21 years of age for the provisions or application of the Child Marriage Act. Second, the bill also extends the time period now for filing a petition to annul a marriage from 2 years to 5 years. What it means that in the earlier bill, after the marriage takes place, after the child marriage takes place, the petitioners have 2 years of time period during which they can get complaint done and get the marriage annulled. Now they can complain till 5 years since the date of marriage if they want to annul the marriage. Third, it allows both women and men now to file a petition before they turn 23 years of age in accordance with the new minimum marriageable age of 21 years. And a new provision has been added that is referred as section 18A in this bill, that has also been introduced to ensure that the bill's provision take precedence over all other existing laws in the state. That means if it is coming in conflict with few other laws that might be related to religion, caste or something like that, then obviously this particular bill will take precedence and will override other laws related to same matters. In this context, the question that is being asked is whether the president's consent is required president's assent is required to ensure the passage of the bill, or whether the bill will become act or not. It depends on the assent given by the president. So let us try to understand the constitutional provision around it. Now, as per the concurrent list that is mentioned in the 7th schedule of constitution, the subject matters are divided into 3 lists, that is union list, state list, concurrent list. Concurrent list refers to such subject where both state and central government can formulate a law. Now, in entry 5 of this concurrent list, there is a listing of marriage and divorce. Thus, both central and state government are eligible to enact laws to regulate the child marriages. So here there is not any problem. However, under Article 200 of the Constitution, governor, once the bill is sent to the governor, he can exercise 4 options. The governor can either grant assent to the bill, he can withhold assent to the bill, he can return the bill to the assembly for reconsideration, or last, he can reserve the bill for the president's consideration. Now, a bill can be reserved for the president's consideration only if the governor believes that it could undermine the authority of the High Court that is functioning in the state. So here, obviously, this subject matter of the marriage and divorce does not come under such categorization. However, why the president's assent is required? Let us try to understand this in more depth. So the potential conflict is arising basically between the central law and state law, and this basically activates or brings Article 254 of the Constitution. Now, as discussed before, the earlier bill that prevents the child marriage was passed by the Parliament of India, and there the minimum age of marriage that has been given that has been mentioned for the girl is 18 years. Now, if Himachal Pradesh bill comes into force, it will override, or it will come in conflict, basically not override, but basically it will come in conflict with the provisions of the central law. So, under Article 254 of the Constitution, if a state legislature enacts such a law on a subject covered by the concurrent list that is repugnant to the provisions of an existing central law. In this case, here this criteria is meeting because Himachal Pradesh government or Himachal Pradesh Assembly is trying to come up with a bill whose provision is repugnant to the provisions of the central law. In that case, inconsistent portion of the state law will be considered void. That means this 21 years of age increase which they have mentioned will be considered void. However, there is another exception that has been mentioned here. If the state legislation is reserved for the president's consideration and receive his or her assent, then its validity can be upheld. That means what we can say, the only way how the increase in age for the marriage of girl child from 18 to 21 years as proposed by Himachal Pradesh Assembly can be valid or can be validated if the President of India, the current President of India, Draupadi Murmu, gives her assent to the bill. Now, in this regard, let us try to understand what do the experts say. So, as far as the child and women's rights activists are concerned, they have for a long time opposed raising the minimum age for the marriage. The rationale behind this is because they say that the existing provisions of the 2006 Act, even if you look at the application of these provisions, it has been frequently exploited by the disapproving parents. That means the parents, when they are not approving the relationship or marriage of their child, to penalize daughters who pursue especially intercaste or interreligious marriages against the familial wishes. Now, in this context, we know that our society is largely patriarchal society. So, increasing the minimum age of marriage, basically they argue, will further entrench parental control over young adults for a longer duration of time. Earlier, it used to be only for up to 18 years. Now, it can be exercised even up to 21 years. So, overwhelmingly, the law has been used by parents against eloping daughters, especially the instances of honor killing and all that we have seen before. An increase in age to 20 years would mean further persecution of girls' right up till 21 years. So, that is why the child and women right activists have been against such kind of increase in the age. So that is all for this particular video. We have to wait and watch and see that how the President of India responds for this particular bill. Thank you very much.